Hey, glad you could be here. It's I guess the title of this says is a Forum Fridays at 2 with Chip Merlin, but I'm actually here with Corey Harris, and
that's a terrible name. So somebody please give us some suggestions for the Friday events.
the Corey Harris isn't such a bad name.
No,
it's the
Forum
Fridays
at 2.
I mean, come on, we could do it. It should be Fun Fridays at 2. I mean, because we're all getting ready. It's Friday. At least it's 2 o'clock in the afternoon, the East Coast time. But you know where most lawyers are by 3:30. So this might be our last bit of work this afternoon before we get out of here. What we wanted to do is I'm trying to keep these down to a half an hour, so there'll be short discussion about some relevant points regarding adjustment and issues that people might not necessarily think about all the time. Who wants to think about proofs of loss? I mean, do you go sleep thinking about proofs of loss? I don't think so. I don't think you wake up in the morning thinking about proofs of loss, but you do think about proofs of loss of the insurance companies, asking for money asking you to fill one out. And the truth of the matter, this came up. So let me tell you how this first topic that Corey and I've got came up. I was doing some research and up popped something from a Facebook thing that Cal Spoon, crazy Cal, and Cal's gotten better and better and better. We've known him for, at least 15, 16 years at least now and stuff like that. And his wife, who I first met after losses in Hurricane Katrina. So that was really 15 years ago. And they are now putting on some classes, and I saw some young public adjusters stand up and say, we don't ever have to fill out, notarized proofs of loss. Well, that might be right in some states, but that it's definitely not right in some other places. As a matter of fact, there was a recent, about last year, a federal court case that came down and said that, where it says you're supposed to notarize these things and supposed to be sworn to, and the FEMA, the regulatory agency, said you don't have to fill them out. Why would you ever listen to a regulatory agency? They could be wrong. Follow what the law says. You didn't fill it out, sorry, you've lost your case, you're out of there. So it made me started thinking about, we need to talk about proofs of loss. And don't get me wrong, I'm going to give out a shout to Cal. I would go to his classes. I think he does a great job. We're not the only place to learn things and stuff like that, but I did want to get back with proofs of loss. And I remembered Corey Harris. Corey first started working. He wasn't even working with me when I first met him. His mother was the president of a condominium association. Corey was about 13 years old, and I was starting to walk around with a bunch of people after Hurricane Opal, and his mother said, follow that attorney around and let me know what he's doing out there, as we were going through looking at all the damage and stuff like that. And then unfortunate for Corey, I guess he's been with me just about ever since, because you worked in undergraduate and college and all the way law school and all the way to right here. So
almost 15 years now.
It's been a long time. Time flies.
Yeah, it does.
Yeah, he went from not having a beard at all. Look at him now, man.
Well, this is a more recent, development. But
it wasn't long ago, about a week ago, it was back down to here, and I swear I thought his wife was married to Julian Edelman, but
Shout out to my barber for making some time for me yesterday, so I looked a little better when we came here today.
So it goes back about 11 years ago now. Corey wrote a blog series, a 12-part blog series about proofs of loss, and so I remember that, and I said this might be a good time to have somebody who is, Mary Fortune is one of our managing attorneys, and Mary says I can't call Corey an expert. So Corey, I'm not calling you an expert on proofs of loss, despite the fact he wrote all these series, he studied all this stuff, he gets up there, he teaches everybody, and I don't know anybody has more expertise in this than he does in the entire United States. So, legally the bar says, and Mary says I can't call him an expert. So Corey, I'm not calling you the expert that you are on this, but I guess
Mary is having a heart attack as we speak.
So, so everybody, how I like following those good old bar rules. It makes so much sense sometimes. I have no idea. But, so Corey, I'm going to let you lead a lot of this on, and I'll chip in as Chip does, as we go through on this. And, oh, by the way, you can always write these questions in. Please write questions. And even if you're watching this on videotape later, because who knows, you might be out on a boat on a Friday afternoon. You don't get back to this until, why would somebody miss this on a Friday afternoon? Proofs of loss. Most exciting thing in the world I could possibly think of on a Friday afternoon, at least until, we get out to start doing this on our Friday afternoon. Now, some people are probably already started on this, but, Fridays are my favorite day, because in a few hours, everybody knows why. But we ought to start on this as we go through it, and if you have questions and you're watching on videotape, send it back into us. I think this is going to be a 4-part series, so every Friday at 2 o'clock, we're going to try to do it for a half an hour. We have 25 more minutes to go on this, so people can learn about proofs of loss. And Corey, you wrote one blog here, and when I was first reading, getting back to the basics, I think that's where everything starts, is at the beginning. So why don't you tell everybody what the real purpose of a proof of loss is, and
yeah.
Go through. Do we have the PowerPoints up real quick?
Yep, the PowerPoint is in the info.
And so people just have to click onto it to go to it, right?
Yep.
And so it's got I'm supposed to tell everybody this, who I am, Chip Merlin, obviously the Merlin Law Group, and it's got my cell number there. And if you go to that's slide number 2, slide number 3's got Corey Harris, when he doesn't have a beard on. Look at him right there, or he barely has a beard at the bottom. But Corey, you're chicken. How come you don't have your cell phone number there? I dare
don't know. I didn't create the slide.
Tell everybody what your cell phone number is.
It's I think everybody's already got it, but it's 813-373-9598.
There it is. So you can always text them or call them if you have some question as well too later on. But that's Corey's number. I'm glad he's not that chicken. And so we're getting back. So the next slide after that, I guess, is number 4, getting back to the basics of the proof of loss. And this first one for 5 is, what's the purpose of the proof of loss and what does it serve?
Well, I mean, the proof of loss has been around, I think, since really the old New York fire insurance policies. It's been in for over 100 years. The proof of loss serves a pretty important purpose. It depends on which side of the claim you're on. But for the insurance company, the proof of loss is really meant to give them information to allow them to adjust the claim, basic information. You hear more and more, in the last few years about insurance companies, especially on commercial claims, talking about the insured presenting their claim. Well, there's nothing in the policy that says the insured has to, quote, present a claim to the insurance company. But through something like a proof of loss, that's what an insurance company can ask the policyholder to do. So the proof of loss, most people that are watching this have probably seen one and filled one out. But generally, it's to provide the insurance company with a certain amount of information that they need to understand, number 1, who has an interest in the claim, number 2, if there's other insurance that may cover it, and really, and probably most importantly, number 3 is, what is the scope of the damages being sought, and what's the cause of the loss?
Well, that's true. So when I teach these classes, sometimes especially on proof of loss, and you go way back to the beginning, like in the proofs of loss, when if you think about it on the marine policies, a lot of the shipping policies and stuff like that, if there's somebody at Lloyd's of London that sells a insurance policy on a riverboat going up and down the Mississippi River, and that agent who sells the insurance to the policyholder, most of the time back in those days, you get back into the middle of the 19th century, the same agent also ends up being the adjuster on the claim. And sometimes the only thing that the insurance company is going to end up getting at the end after, quote, its agent who sold the policy and then adjusted the loss is, because they didn't have photographs back in those days, is a proof of loss that's filled out and agreed to typically by both the agent and the policyholder with something signed to it indicating what the amount of the loss is and whatever information they want. But as you'll see and we'll talk about, especially over these 4 different classes, I tell people, especially on the more modern policy forms, they'll say you're supposed to buy proof of loss, and then it'll say what you're supposed to have in on it. And some of the policies, they don't even have, you don't have to write down what the amount of the claim is. Like a lot of the Lexington and Chubb policies, the amount that's asked for isn't there. And we're going to show you a proof of loss, and instead what you're getting are questions like, the ones that probably are pretty important. Is there another insurance policy that's insuring this? Because if there is, we want to know about that. What's your interest in it? Do you have an insurable interest? And that's really one of the first questions every single insurance company adjuster is supposed to be asking when they're out there is, hey, what's your interest in this property? Did you sell it beforehand? Do you really own it? We got a case going on in Panama City where this insurance adjuster paid over $2 million to the person that even owned the building. It was the tenant, and the tenant got kicked out. So the tenant shows up, gets somebody that, fly-by-night estimator to get up an estimate for a lot of damage. They had the policy issued in their name to begin. They don't own the property. It was supposed to go to the owner, and so we're in you can imagine we're in litigation on that right now. But that's what the interest is, and then is there some you know, who gets paid, the lost payees, I think.
Who's got an interest in the claim, who's supposed to be on the checks, you know, things like that.
And so that's, you know, it's pretty important for that type of information so that the insurance company's making payment to the right parties afterwards. But the proofs of loss have been around for a long period of time, and the marine forms especially coming through, and I've been doing some research on that, maybe because it kind of, you get pretty nerdy when you start doing this stuff, and you start saying, who figured these proof, like, where did the form first? And I'm literally doing some research trying to find out what's the oldest proof of loss I can find somewhere. So,
all right, we got a question here. We got a question here from Jan Miller. It says, can you ask Corey about if the insurer requests a proof of loss within 60 days and is supposed to furnish a proof document, but doesn't? Does that do anything to the demand, and is it valid, etc.? If the policy says that they are going to provide you with the form, they're supposed to provide you with the form. If they haven't, they technically haven't complied with the policy. I don't know that I would want to be going down the road of trying to make the argument that we ignored the request because of that. I'd probably be asking for the form, and if they don't provide you with one, I would probably take out a normal form, fill it out, and send it in for them to take a look at.
Now, Jan, there's I think when we get further in, Megan, who's watching over us so we won't mess this up too bad, I think I provided an old Cozen and O'Connor link. It was made in 2007 with all 50 of the states and the proof of loss requirements, depending upon, and this goes state by state. So one of the things about the tricks and the traps of proofs of loss is you got to know what state you're in and what proof of loss, you know, regulations, statutes apply in that particular loss. You have to know whether it's if it's a fire loss, whether or not the 165 line policy, the standard policy applies, or is it going to be another, you know, portion under the regular read type policy. But you'll find in some states that the insurance company doesn't provide the forms within a certain amount of time. All those forms are waived as a matter of law, and I mean, Louisiana, I think, in my opinion, has got probably the most liberal definition then of what a proof of loss is. There's one case that says you can point to where the loss is, and you tell the insurance company to go take a look at it, and that's, quote, your proof of loss. So,
good old Louisiana.
Good old Louisiana. So when you ask a question, you know, like that, I think the first things that people really should do, and you got to get aware of if you're adjusting a loss or if you're the policyholders, I know that a proof of loss is a requirement. I should be filling it out most of the, you know, but what state am I in and what really are the regulations? So when you ask something, you know, about that, you're going to get the right answer. So
yeah, each state's going to be different, and then you've got the FEMA proofs of loss that are a totally different thing that's subject for another day. But those are all different than what every state law is out in the country. So
yeah, if you have a national flood insurance proof of loss, and this probably go for any type of proof of loss involving a nationally backed insurance program. I saw somewhere, and I was real busy, and some attorney was asking a question about a agri loss, and I started thinking, oh my God, please don't be under the, you know, a crop policy that's, you know, by the federal government, because they have the same type of requirements there. You got to fill this out. You got to dot your T's. You got to cross your T's, dot your I's, and do it exactly on their form and have it all right there. And if you don't do it, you don't do it on time, baby, you're out of there. So it's on national programs such as national floods, such as some of the federal crop insurance backed things and stuff like that. For heaven's sake, you know, go get their form, because that has to be on their form, and it's got to be filled out exactly right. And if you don't, I can't say screwed, can I? But I can say you won't get the money.
You just said it.
Yeah, you kind of just did. So
so that's a big, you know, warning, and that's come when somebody said you don't have to get a notary signature on something. It's like, well, it depends on what kind of loss it is. It depends on what state you're in, and it depends on what, you know, happens. And sometimes it's a lot easier. And you know, we'll get to a couple of points at the end, but. You know, the basis of the proof of loss is for the insurance company to have, and I think most people say it, I quote, from the insurance company standpoint, a formal claim has been submitted by the insured, by the policyholder, for which the insurance company can accept it, can reject it, or can acknowledge it. And we can, you know, talk about all that later and as we go through this. So filling out a proof of loss, you know, when's it not required, Corey? Because
Well, it's going to depend on it's going to depend on the policies a lot of times. We just had a comment on the Facebook thing here that said, you know, most policies state that the proof of loss is only required upon their request. And that's 100% true. If the carrier doesn't, if you have a policy that says we have to submit a proof of loss, or you have to submit a proof of loss upon our request, they don't request it, there's no requirement for you to submit the policy in order to be paid on the loss.
Okay, so here we go. Lesson number 1, you already heard that. What type of loss is it? And then what state are you in? Okay? And why is it important what type of loss it is? If you're in a 165 line policy state, and it says to the effect that you got a fire loss and you got to submit the proof of loss, you have 2 different types of insurance policies. You have a policy that has you've got to do it within a certain date, usually 30 to 60 days. And so you have a 30 or 60 day policy. You have to submit it within 30, 60 days of the loss. And then the second type of policy is it's a request policy. The more modern form policies have at our request, you've got to submit a proof of loss. When we request, you got to submit a proof of loss, and then it'll usually say 30 to 60 days thereafter. I have seen some 20-day ones, but it's usually, you know, 30 to 60 days after our request. So if they aren't requesting one, which is I think the point you were saying, you don't have to submit one.
If they don't request it, you don't have to give it under those types of policies. But State Farm, for instance, in Florida, there was a lot of litigation going on with State Farm after the Hurricane Wilma claims. Where State Farm had a policy that said in there you had to provide a proof of loss within 60 days of the date of loss. And State Farm would go out, they would adjust the claim, they would make a payment, and then the insurer would come back later and say, well, wait a minute, we got a supplemental claim, we're entitled to more money. And State Farm was litigating them, saying, no, you didn't submit the proof of loss back at 60 days from the storm, and now therefore you're out. And that issue turned into a heated debate that went on for years and years throughout different courts and had different rulings.
Yeah, in Florida, but Florida had a good rule for a long. The old Florida rule used to be, and sometimes they recited. There's a couple cases that, but one in particular, there was a case I was convinced the insurance company was concerned that the person had burned down their structure, and they waited up until almost 5 years on the date, and they submitted a proof of loss within 5 years, and they argued that they only had to submit the proof of loss within 5 years because there's a 5-year statute of limitations in the state of Florida. They said once they submitted the 5 years, the insurance company got it, and within that 5 years, they turned around and then denied the claim. Then the policyholder, so they submitted the proof of loss within the 5 years. Almost immediately, the insurance company denies it, saying it's late, and then they filed a lawsuit after the 5 years. And when Florida Supreme Court came back and said this just used to be pretty much rote law. So long as the insurance company, you know, is not prejudiced by the late filing of the proof of loss, the time frame for filing a proof of loss is within the statute of limitations. You couldn't go longer than the 5 years and submit a proof of loss. And by the way, the 5-year statute of limitations starts not on the time of the proof of loss, not necessarily on the date of the loss, but if the insurance company then denies the claim within the 5 years, it starts the clock ticking all over again. So literally, you almost get 10 years if you wanted to in Florida to file a lawsuit. You know, if you had a real late proof of loss. So again, that is a Florida rule. You can't do that in New York. You'll be out the door. And I think, Corey, you cite some cases in there about when that, you know, it's real bad if you don't submit it timely.
And so, yeah, some states take a very draconian view of when it can be done, what the consequences of not doing it. And we have another topic coming up in a later part of this series talking about what happens if you don't file the proof of loss, and we're going to go through some of those areas. But there are some that are very strict. Some states are very strict. Some states say if you don't file it within that time, you are out. Some states look at prejudice. Some states say, well, it's not really that big of a deal. But it just all depends on the state you're in and the policy that you got.
Well, if you don't file it on time and they deny your claim, I can tell you what you should do. Call Corey Harris, because he's not an expert in this, because I can't say he's an expert. He might be the most expert lawyer I know in this field, but again, Mary Fortson won't let me say that.
We've got another question here. It says, if it's a submit the proof of loss upon request policy, do you recommend sending it as soon as possible regardless of the fact that you don't have to, even if they don't ask for it? So if the policy says you only have to submit it when there is a request, should you send one anyway?
Who asked that question?
Rand Man.
Rand Man. Man, don't be afraid. Say your name, unless your name really is Rand, R-A-N, man. But, so here we go. And so I'll bring up, Corey actually wrote in one of his blogs, typically he says you should file your proof of loss as soon as possible, but I don't think that had to do with in the request front, because this is what happens. If you have a request policy, or if the insurance company says even if you have a time policy, you got to submit it within 30 or 60 days thereafter. Sometimes the adjusters come out and go, this is a complex loss. We are going to let you waive your right to file that proof of loss. You don't have to submit it right away, even though the policy says it. And on the request, when they say the adjuster's out there saying, we aren't requesting a proof of loss, let's go through the adjustment and see if we can come to an agreement first. So you have this term that is rarely, it's hard to find, and you're not going to find in case law. You might, because there's been some cases talking about what you have known as an adverse proof of loss. In other words, an adverse proof of loss is one not requested. They haven't requested one, but you know what your number is and you want to get the claim going. And I often tell people, when you read the insurance policy, what happens after the proof of loss gets sent in? What's the insurance company supposed to do?
They have 30 days to notify you of their intentions, whether they intend to elect to repair, they intend to pay, or they intend to take the property at salvage.
So that's it. I mean, sometimes just the first two. The third one is to take it at salvage. So
there is a misconception that the policy requires them to actually pay you the money within 30 days. Typically, that's not the case. Typically, what it requires them to do is tell you what they intend, how they intend to settle the claim on, what basis they intend to settle the claim on, whether they're going to elect to repair or they're going to pay.
So, Rand, in order to properly answer your question, you can submit it within a shorter period of time if you want to. You can do it all day long, and sometimes I do it quicker if I think the insurance company is just going to delay the thing. Many times what we're trying to do is, especially if insurance companies will do, if they're acting in good faith, every insurance company should make partial payments of what they agree is owed without a proof of loss being signed. You'll rarely get a Lloyd's company to do that because they always seem to want a proof, but then we will literally have a partial proof of loss for the undisputed amount paid filled out, just to satisfy the requirements. I'll go along with that, but what you're asking me is, can you submit what them as soon as you want? You absolutely can do so, and what it triggers typically on 99.9% of all the policies is they've got it. They got to tell you, we're going to make a payment, or we're going to elect to repair, which they rarely do, except if you're in Florida with managed repair. It's going on a lot more now. Or, oh, we're going to do the salvage.
We're going to come in, we're going to salvage, so that not to dispense with all the properties.
It doesn't mean that, oh, hey, they accepted your proof of loss. That means that they're going to pay you the amount that you asked for. No, no, no. A lot of people say, oh, they accepted my proof of loss. They didn't deny it. They didn't reject it. They owe me the money. No, that's not what it means. There's a whole nother provision there. Just because they accept the proof of loss and don't reject it doesn't mean they agree with everything that's on it. If you've technically filled everything out and it's technically proper the way it's filled out, an insurance company should never reject a proof of loss. It should be accepted. That doesn't mean that they acquiesce in what the amount of the claim is. It doesn't mean they acquiesce in anything that you've written down there. That means you just technically filled it out properly. That's all it means.
That's the only reason insurance companies, for a technical deficiency in the filling out of the proof of loss, that's the only reason they should deny the claim, deny the proof of loss or reject it. Typically what you see is they'll say, we accept it as compliance with you've complied with the policy condition, however, we're not in agreement with the number, and off you go. We got another question here from Michael Harker, and he wants to know,
Michael's a pretty smart guy. What's his question?
He has been told.
Let's see if he asks a smart question too.
He says he has been told that a proof of loss can be useful in making a claim for interest on delayed settlements. In Arizona, I believe you cannot make a claim for interest unless the proof of loss was filed. That is a very good point. I won't get into Arizona law because I am not licensed in Arizona, but I can tell you there are a number of states around the country that have provisions, even some fee shifting provisions, where if you submit a proof of loss and the carrier doesn't pay it, and then it turns out later you were able to prove they owed you more money in court, then it shifts the attorney's fees that the insured incurs for bringing that case can get shifted to the insurance company. So yes, each state's different. Each state has their own requirements. That is not a law that we have here in Florida, but there is other states. Oklahoma has a law like that, I believe. I think Idaho does as well.
Yeah, there's some states that have got some I will say some older statutes and really not proper statutes, if you think about it. Virtually every state has an obligation now has an obligation by the insurance company of having to promptly adjust the amount, properly adjust the claim, which means they're supposed to go out and investigate the facts and evaluate the amount of damage, and they have to do this right away. And they have to do this regardless of what goes on by the policyholder. That's their obligation. Some insurance companies say, we don't have to do anything like that. Well, that's not true. After the loss, you're supposed to, yet the same states also have these other statutes that says that it's a unfair trade practice if the insurance company does not start to investigate the claim and acknowledge at least the receipt of the proof of loss within 10 days, as I recall something in Florida statute, I think it says 10 days after receipt of loss, you haven't started investigating the claim. Really? So, I mean, it's kind of a stupid statute. It's been around for a long time, and it's to the antithesis of these other statutes. You know, so I hear what you're saying, and I absolutely agree with you. In some states, it's really good to file that proof of loss as soon as you possibly can. I think Corey's, in the blog post you wrote, typically it's a good thing to file your proof of loss as soon as you possibly can. Some people don't like to do that. I've heard public adjusters say we don't like to do that if what we believe is the insurance company is acting in good faith, making partial payments, and what we want to do is come to a mutual agreement about what the total amount of the loss is. And there's some reasons for that too. I can give you any number of them. The policyholder is not going to go and rebuild right away. They're going to rebuild at another place, and they want to get paid on a replacement cost basis, not an actual cash value basis. And the policy says we're not going to pay you on a replacement cost basis, and you actually replace. And oh, by the way, the code upgrade provisions only apply if you do your replacement at that premises and after you've done the work. Those things can be waived, and you can write a different proof of loss out if the parties come to an agreement. You can always waive and agree to different terms in a contract if people do so and amicably do so, and they can all work it out. So insurance company might save a little bit of money this way by acquiescing some, the policyholder get a little bit more money, and everybody just move ahead. Or, you know, we can't exactly agree on what the value is, and we're going to wait a little bit until we can, and then wrap it up and not worry about having to go get back because, oh, I was trying to do this. I found time. Uh-oh, let me find it. My old shoe. I got my old shoe. See, Megan, I got the shoe. See, I don't know what the value of this shoe is, but they're not going to pay me the $350, assuming it is $350 with tax, brand new. It might be worth only $100. And if they want me to fill out a proof of loss, maybe they'll pay me $275 right away, and not have to worry about me going out and getting the receipt for the new pair, and we'll just agree, and I'll give a proof of loss, and we're all done at the $275. I got that shoe in there, you know. And I got the three monkeys right here too. So we got the three monkeys. So this is always a reminder. Think about the three monkeys every time an insurance company does not go out and promptly adjust the loss. And even when they do go adjust the loss, you know, a lot of times they don't see where all the damage is. They're not going to listen to you, the middle guy, of where you're telling them all the damage is, and they might not tell you all the benefits you have available under your policy. So always remember that on insurance. I know some insurance companies out there saying, Chip, we don't act like that. Really? When you think of those insurance companies, you think of these three monkeys, okay? All right? So I got the shoe and I got the monkeys in today. Is there any more questions out there?
There's a bunch of questions, but we need to move on.
Well, let's answer the questions then.
All right.
That was Rain Man.
Let's see.
Roger Borg, did he have a question?
We got a couple. I'm trying to get this.
Roger said that you look good.
Oh,
Is that
thanks,
what he
Roger.
said?
It says, I got one question here from Brian English, and wants to know, for the 30 days, notice of the carrier intent after the proof of loss, can they respond with a reservation of rights to further delay? They can always respond with a reservation of rights. They can do that all day. The policy doesn't say you can or you might have to provide your intent. They're supposed to give you notice of intent. Now they can tell you this is what our intention is, subject to our reservation of rights. But there's nothing in the policy that allows them to miss that 30-day deadline. Now in practice they do it all the time. But there's nothing in the policy that makes it iffy on whether or not they have to give you notice of what their intentions are.
So I'm gonna go back, it was probably 1983, 1984, at a Florida Advisory Committee on Arson Prevention, a seminar up in Ocala, Florida. Paul Butler was giving the speech, and somebody asked about, well, shouldn't we send out a reservation of rights, you know, after they send in the proof of loss? And Paul said, where in the policy does it allow you to send in a reservation of rights? And then Paul said, you know, why is you sending the reservation of rights in after you have a proof of loss that comes in? And he goes, why do you even have to do that? And this was his point. And he's teaching insurance company adjusters this. You know, I used to represent insurance companies for my first couple of years out. So here we go. He says, why are you even doing that when under Florida law, there's a statute that says an insurance company, by the investigation of the claim, you know, still reserves all of its rights under the insurance policy. So why are you sending out a reservation of rights? And sometimes people who do a lot of liability claims handling, catastrophe claims handling in every single state regarding a liability claim, if there's a possibility that you might be denying that claim to your own policyholder and not providing liability coverage and not providing a defense after they run somebody over or something like that, you got to let them know right away, and you got to do it typically with a reservation of rights that's very technical.
And if you don't, you waive it.
And almost every jurisdiction in the United States, that doesn't apply to property insurance. Yet we start seeing, we're hereby reserving our rights, and we're, and you know, you get this stuff, and and for some reason, I ask people, where's that say in the policy? Why are you doing that? And then they're, you know, what gives you a right to do that? And you pull out the statutes right here. It talks about reservations of rights, later liability. Wouldn't you agree it's not a liability policy? Are you so stupid that you don't know this is a property insurance policy, you stupid property insurance adjuster? You know, but I don't quite say it like that, but I think everybody thinks, God, you must be pretty stupid for doing something like that, and you're scaring the bejesus out of, you know, your poor policyholder for sending a reservation of rights letter. Why don't you just be nice to them and adjust the claim? Anyway, I shouldn't get like that.
So
but it does, if you got one, you'd be pissed off too, you know? I thought these guys were the good hands people.
So Roger Borg wants to know, when they reject the proof of loss, does that affect the 3 triggers? Typically what the policy says is that they talk about an acceptable proof of loss. So typically, if they've got a reason to reject it, that you didn't fill it out properly, then yeah, it could extend the 30-day time frame until you file a proper proof of loss.
So if you do some research in here, you'll find out rejection of a proof of loss, and almost every single property insurance attorney worth his salt representing the insurance company is teaching their adjusters out there, for heaven's sake, just because you disagree with the amount that the policyholder is claiming, don't reject the proof of loss. They have a right to put down what they think the claim is. As a matter of fact, they have an obligation to swear to what they think the amount of the claim is. If you think about it the right way, what is the amount of the loss? And you're going to swear to it. Why would, you know, they have a right to put that down if they have a basis for it. You know, everybody has an opinion if they have a base, but you can't just go reject it. You reject it, insurance companies reject it for other reasons. A rejection is actually, they rejected my proof of loss. Now I'm kind of stuck. It can lead to a lawsuit. That can lead to a lawsuit.
So Randman's back and wants to know, not can you submit a proof of loss of your own accord without being requested, but should you do it? To get the statutory timeframes and timelines started. It depends on, each circumstance is different. You can't give a blanket rule. There's some instances where you may not want to submit a proof of loss. I term it as a hostile proof of loss, so that's just kind of the way it's been passed around lately. But there's sometimes you want to do that, or sometimes you don't. It just all depends on the situation and what your circumstances of your claim are.
I mean, you can even start answering all. When you go through the insurance policy, most policies, they're going to have a section in there about what it is that has to be contained within a proof of loss. And so they'll say, you know, the date and time that it happened, what the interests are, what the occupancy is, all these things, and you have to go ahead and list all these things. And once you do that and you send it in, and they have that information, the only extra thing that a proof of loss would do is actually make it sworn and notarized, you know, for the insurance carrier. If the claim's looking like it's going to be going good for you, and that works for you, great. If you want to be one of the most aggressive guys and you're be claiming, you know, interest, and you're trying to stick everybody up, and that's just your modus operandi of doing claims handling, then I guess what you would want to go do is file it as soon as possible. That's not particularly mine. I think it depends on who's on the other side, and I typically say you better know who it is. But then you know, when you're gonna be that technical on somebody, you better be ready for it to be that technical back on you as well too. And that can come back to haunt you, you know, later on. I often say that there's a lot of really good insurance adjusters who get their claims settled. They don't end up with litigation. They get things paid for. We don't see them a lot in our practice because they get their stuff taken care of. There used to be a guy named Bobby Wilcoxon for Hartford. He did everything down here in Florida. Maybe one lawsuit that I had, you know, and he retired. Next thing I know, they send in 3 to 5, I forget, Hartford younger adjusters. Great for my business. We're filing lawsuits all the time. Good old Bobby's gone. These guys are trying to show the Hartford claims guys they're tough as nails, and we're filing a lawsuit, you know, all the time. And so it's just, why would you ever want to get Bobby upset by, you know, filing something on him? Because he really was an adjuster that was doing great by the Hartford and doing great by Hartford's customer. When he left, you know, those days are kind of gone. Why would you do it to a Chubb adjuster, to an Amica adjuster, to maybe even a pure adjuster, to people that have reputations for paying claims and things like that? You want to get somebody upset with you on that, you know, knock yourself out. So I think the first thing that Corey said about it being a case-by-case basis is a lot. And sometimes I know I talk about the monkeys out there, but there's a lot of non-monkeys that are very, very good professional adjusters, and I would suggest the best public adjusters and everybody else trying to deal with those professional adjusters would be better off if they just did their job really, really good with very high interpersonal skill sets and just back it up. You don't need to see attorneys that much. It was never meant to be that way.
So, Bill Cook's asking, what are the requirements for the insurers to reject a proof of loss, and what are the penalties for insurers failing to comply with the proof of loss or with providing notice of intent? The only, I think we said this earlier, the only thing that an insurance company can reject a proof of loss for is if it's not technically filled out properly. If
yeah,
it's
just
not
leave
signed,
it blank.
If it's
Don't
not
have
signed,
it signed.
it doesn't provide the information requested. You know, those are the kind of things they can do. The penalty for an insurer to not comply with that, it's a breach of the contract. If they don't notify you of your intentions, it's technically a breach of the contract. There's some case law around the country about, you know, what the effect of that is, but and whether, you know, things like whether they can still invoke appraisal and stuff like that afterwards. But technically, it is a breach of the contract for them not to do that. Now, it's also evidence of bad faith. If they have no reason not to notify you of their intent, and they don't do it, and they drag the process out, they're not promptly adjusting and handling the claim.
You know, and it's not just filling it out; it's also getting it to the insurance company the right way. I think Corey cited a couple of older. I remember the Tennessee ones. That's the worst when they gave it to the local office. Everybody admits the local office got it, but you know what? It's said in the policy to send it to the home office. Supreme Court comes back from Tennessee, says you didn't send it to the home office. You're out of there.
That's why you've got to look at the policy language. I mean, this was also a case from the late 1800s, early 1900s.
1911.
So things have changed a little since then,
but not for federal. And that's
right.
When you go to federal flood, you got to send it to the insurer, and they're going to have it where it's supposed to get sent to. And it's got to be by that day. It's 30 days. I'm putting it in the mail. There's no mailbox rule. It's got to get there by that time. And you know, we've literally had people like, it's got to get to where it's supposed to be, and not just necessarily the mailbox. I mean, to the insurance company, it's got to get there. You got to have proof of it. Well, you should get proof of it. As a matter of fact, I've talked about. I personally start to use Federal Express, UPS, overnight mail, where I know it's going to get delivered, and I got proof of it being delivered. Sending it certified mail can take 10 days for some reason, and if it's got to be delivered to us. If it says, the policy could say you've got to have the at our request, you have to have the proof of loss delivered to us at our home office within 30 days. You better not be late after the 33rd or 34th day. In some states that say time really matters, so you know, those little things are important, you know, as well. So when you start talking about, you know, being really technical and filing these things early, what happens is they say, oh, okay, we got your proof. I guess they're supposed to say they rejected it, but you know, and would tell you what your technical deficiency is. But they also, people will remember if you're going to be that technical against them as well too.
So Bill Cook asked, what if the insurance company is not
accepting? I love Bill. You know, Bill's got a great, you know, if everybody look, Bill, William S. Cook, and if you look him up, he has all these public adjusters and other people are claims handlers, and he does his own educational series, which I think is really good, and Bill's great with the hypothetical question, aren't you, Bill? So Bill's question is,
what if the insurance company says that they are not accepting
really
or
what
rejecting?
he's trying to, it's like stump Chip.
Yeah, that's
Let's
what
see
it
if we
is.
can stump
That's
Chip.
what it
Here we
is.
go. What is it?
So what if the insurance company says they're not accepting or rejecting the proof of loss at this time? That happens all the time.
You know, it actually does happen all the time.
It's based on a fundamental lack of understanding of when they can reject the proof of loss. That's an inexperienced insurance adjuster that's saying we're not accepting or rejecting it because they think it's about agreeing with the number, and that's what it boils down to. They think that we're not. If we say we accept the proof of loss, we've somehow agreed to the number, and if we say we reject the proof of loss, we're rejecting the number, and that's just not the case.
And so this is the way Corey, who's not the most expert person in the world, would handle this. You know, in a deposition with them, says, okay, this is the proof. This is where it says, and this is the section about the proof of loss, right? Where does it say we're going to accept the proof of loss? Nowhere. Where does it say you're going to reject the proof of loss? Does it say anywhere that it says you're going to accept or reject the proof of loss? No. What's it say you're going to do after you get the proof of loss? Tell us if we're going to make, and they're reading it probably for the very first time. I mean, a lot of times these adjusters are reading it for the very first time. Somebody got them in some stupid claim class. We're not going to accept or reject the proof of loss at this time. Look, just because it's what it requires them to do is we're going to pay. We're gonna repair or replace. Typically, those are the big two that are right there. That's the only thing they have to do. Some insurance companies still teach their claims adjusters the wrong way, or somebody's taught them this myth that, oh, if you don't reject that proof of loss the way it is, you owe them the money.
They're scared to death of the proof of loss. What it could do. I mean, that's what it comes down to. Oh, if we say we accept it, we somehow have to pay them all this. We've agreed to pay them all the money. And that's just not the case.
Maybe for some of those people don't know what they're doing, maybe what I try to do, Bill, is send in a proof of loss, says, here is our formal proof of loss, formal statement of proof of loss. Please, be governed accordingly, I guess. I don't know, and scare them if they don't know what they're doing.
Well, I mean, it's highlighted by the fact that if you look at a lot of appraisal provisions, especially older appraisal provisions, it said appraisal could be invoked within a certain amount of time after receipt of an acceptable proof of loss. So the accepting a proof of loss doesn't have anything to do with the number. It's accepting that you have complied with the requirement to provide them the information.
I've seen some very polite letters. Thank you very much for your proof of loss. We've got it. It appears to satisfy all technical requirements. However, we're not in complete agreement with it. We've decided that we're going to pay the loss for whatever is owed. Here's a partial payment for the undisputed amounts. Which you can use. This is our estimate for determining what it is. When can we go meet and stuff like that. And of course, then next thing we know, after some insurance carriers write that out, and then I'm up there in the legislature trying to explain why AOB shouldn't be thrown out when the first response back from the contractor is to a nice letter like that doesn't happen all that often, but it does, and they will show that to the legislatures. Oh, we got a lawsuit, right? How much is owed? Let's see if we can figure this out. And so people ask how come Florida had all kinds of changes in AOBs and stuff like that. But anyway.
All right, so Matt Hunter asked, he says, I'm handling a State Farm claim in Georgia. The policy requires a proof of loss within 60 days. I got the claim 6 months old, where the insured did not submit the proof of loss. And State Farm did not request it. It's in my notice of rep requesting a form where State Farm still did not send the requested form, and the claim is stalled. What should I do?
Okay, well, so what I try to do, if you look at the State Farm form, I believe it says exactly what you have to place in the proof of loss, and I've literally filled out a proof of loss, got my policyholder to swear to it, and we've sent it on in to them that way, because I know exactly what you're talking about. We're not requesting it, and that's sort of the question there. So what do? Go to the State Farm policy, and it has it listed right there. There's another thing you should do if it's getting delayed. That's if they're being jerks about it, guys, all bets are off. First thing you do, and I don't know why we don't do it more often, I always go to departments of insurance, and I've been to a number of them, not so much this year, but at this time last year, and the Department of Insurance tell me, Chip, we don't get any complaints from the public adjusters about, we don't get complaints from the policy. Well, why don't they complain to us? We know this is what's going on. What you're telling us might be true, but nobody's complaining about it.
Well, I can tell you after Hurricane Michael, they were inundated with complaints from up there because Jimmy Petronas told them, everybody's got a problem, don't hire an attorney, don't hire a public adjuster, just come to my office and we'll take care of it.
But even there we found that, because I was in some of the internal discussions, because Florida's got a Department of Financial Services watches over the adjusters in an office insurance regulation, and sometimes the two don't hear each other's, complaints, which was a topic I don't think is going on now after I suggested and people saw what was going on. But file complaints against insurance company adjusters for ignoring policyholders, ignoring the claim, not doing their job, just being a horse's ass, on things. That's one reason you should never be that way either. Most of the time, most states, if you're a public adjuster watching this, requires you to be professional, not say anything demeaning about the insurance company adjuster, and stuff like that. As a matter, if anything, I'd be contrite about it, and if you consider adjusting to be a noble profession on either side, I would suggest these types of gamesmanship things should not go on. In Georgia, unfortunately, I know they do. I've been shown a lot of things, and if it's the smaller the amount, the more it goes, because Georgia has, in the way the case law has been interpreted by the courts, really bad faith cases, nearly impossible to get bad faith up there. And then with respect to appraisal, the insurance companies always say it's causation, and unfortunately, there you go. We're not going to go to appraisal either. So how do you really file a lawsuit over $10,000 to $15,000, in the state of Georgia and be able to afford it yet? That's what insurance companies are often doing. Maybe, Megan, what we ought to do is copy this, and I'll send it to the Department of Insurance in Georgia. They've had a change up there. I've met some of the deputy commissioners. I think they want to do something about this. They ought to change the laws up there. So Allstate especially, who's doing this to everybody up there in Georgia, isn't doing it any longer. I hear a lot of complaints about Allstate Insurance Company about that. For you, the attorneys up in Chicagoland who take over for Allstate, I'd gladly talk to you about it. You guys told me a long time ago just to give you a phone call chip before you sue me over $425. It ends up to a $25 million class action settlement. But there have been some problems with the Allstate Insurance Company up in Georgia about treating their policyholders fairly, and many times I have a lot of examples about that.
Aloha back to you, Mr. Jocelyn. How are you? He has a question for us.
My God, he's starting early on Friday already. He's 6 hours behind us. I'm surprised I guess
he may still be up.
He might be.
So he says, what's the best practice for executing a policyholder's proof of loss while losses are continuing, such as these times with COVID-19? The losses are mounting, yet we want the proof of loss.
So
yep.
I hear you loud and clear. So let's pretend it's a business interruption loss, and we have 12 months of time that are going on. I have literally told people you ought to be filing proofs of loss every single month. Here's our first, maybe every single week. If it's a big enough manufacturing thing, maybe every single day. And you say this is your loss for this amount of time. You explain it's not the full amount, but you want to get paid as you're going along, so you get your business interruption taken care of. I don't know why you wouldn't do it the same way for those other things. So I've spoken about this a lot on business interruption losses, because the insurance industry is no longer doing it the right way. They don't even train their adjusters how to do business interruption losses. They third party it out to accountants who now do it. And when do the accountants start? 3 months later, the people need their money right away. They don't even start sometimes. That accountant ought to be in that office the next day, going through the books and records, working with the bookkeepers, working with the accountants, and they're not out there doing it. The adjusters aren't out there doing it. Business income and business interruption claims are great bad faith cases, because most of the time the insurance companies delay doing those claims, and they haven't even trained the adjusters how to do them. They have outside accountants do it. So that, just knowing what that is, you've got to, if you're the policyholder and you're a business, you can't wait for your insurance company to do it. You should be asking for that right away, asking for them to go do it. You ought to be submitting your losses as you go along so you get paid, because the period of restoration starts typically 72 hours, 72 or 48 hours after the date loss, and goes through the period of restoration. And maybe you have an extended period of 12, another month, 60 days, 90 days. If you have an English form, it just keeps on going, man. But you don't see those English forms out so much anymore. That's my answer to that, Robert. It's a great question, because I don't think, even on the policyholder side, there's enough emphasis placed upon getting the businessman back his business income, and then number two, even more importantly, that extra expense coverage which they need right away And the only way to do that, if you really need to make it formal, is to, you know, submit that proof of loss. Hopefully, most adjusters should say, hey, we're gonna take care of you. Here's the partial monies we're going along. We'll figure it out later. I know they're out that much, but they just don't train their adjusters that way anymore.
In regards to the second part of his question was whether or not it's a good idea to highlight on there that it's on the proof of loss that it's preliminary or initial. You know, just as important as what's in the proof of loss is the cover letter that you send with it. You know, if there's something about that proof of loss that you need to explain, that cover letter needs to go with it saying, hey, here's the proof of loss. This is for this period of time. It's going to keep going up. We're still incurring losses, but we're giving this to you right now. We'll supplement it later.
Yeah, the reason why it's not right, and it would be actually a technical rejection if they, without some type of explanation for it, if you're saying this is the amount of our loss, and you know it's only partial, what you're really doing is you're having your policyholder swear or somebody swear this is the amount of the loss. That isn't the amount of the loss. It is the partial amount of the loss up to this date, or it's our claim to this date, you know, if it's a time period, you know, type of loss. So yeah, you better have that, and you should always have the cover letter and the documentation which shows the rest of the loss with it. You know, I often, the best rule for everybody is you almost have to assume the insurance company somehow, they must have a lot of dogs there to eat their, like dog eat the homework, they must have dogs eat the proof of loss. Because I swear to God, we can't find the proof of loss. We can't find the documentation to the proof of loss. And so what we have people do is scan everything in, and make a hard copy, send it, email scanned versions with it all there, even to drop boxes where they can get it. So there's none of this excuse about the dogs that must be running around in the claims department eating all these proofs of loss, because everybody knows what I'm talking about. They're there. There's probably right now the guys back in the home office of the insurance company, Chips exposing all the problems we got that. Or maybe we're gonna have to go put some fat dogs out there to eat nothing but proofs of loss rather than, you know, I don't know. You can tell it's Friday. I'm starting to think about having some fun, but anyway. What else?
That gets us to the bottom of the questions.
Yeah, this is supposed to go now.
30 minutes.
51 minutes. We're supposed to end 21 minutes. Are we done for today?
I think we're done for today.
Hey, Robert and everybody out there, aloha! I hope everybody has a great Friday. We'll be back Tuesdays at 2 with not somebody who's good looking with a big beard. He has a real short one, kind of chic and stuff like that.
Yeah, this takes dedication.
You know, but you got a little bit of tan.
Yeah.
Just for everybody who comes on Tuesdays, Larry Bache is not sick. I know he looks like he is
He's
next to me,
watching right now.
but he's not. He's watching right now?
Yeah.
Larry, I'm letting everybody know that you're not sick. And you saw Corey gave him your cell phone because he's not a chicken guy. How about that? Guys, y'all have a great weekend. This has been a lot of fun.